trial, the ambulance trial last year, in which Dr. Kesi was standing trial with 2 others. We are now understanding that he also put before the presidency another petition, this time around seeking the removal of His Lordship Justice Yoni Kulendi in respect of the same matter. We are only able to tell because what we gather is that from what was contained in the statement or the petition to the CID, it's basically on the same issues that have now been put in a petition again to the presidency. Mind you, this will come directly under Article 146, and as the law is, when it gets to that stage, matters are very confidential, supposed to be in camera, right from the petition to when the committee is done with its work, that's if it ever progresses to that level. But the only reason we are able to understand what went into that petition is because we have already dealt with a certain leg of this matter, which is before the CID. And the understanding we get is that this petition, which we understand has been submitted to the presidency, is also predicate on the same or substantially on the same set of facts, Alfred. So that's what we are learning.
I see, but then again, if this is to be considered, and we're very mindful of the boundaries of our conversation on this as well, because as you indicated, it's early days yet. What's the process going to be? Well,
so that's also opened up another conversation which has been a very controversial one, and that has to do with the removal of the Chief Justice. Now there's an argument whether if the Chief Justice is removed as a whether the Chief Justice removed as a Chief Justice also loses the position of a Justice of the Supreme Court. Those who think that should not be the case argue that the removal process for a Chief Justice is different from the removal process of a Justice of the Supreme Court. In this case, if it ever progresses, we'll be looking at the removal process for a Justice of the Supreme Court. And that takes us, again, to Article 146. Except this time around, we are looking at it from the point where this would trigger a process that will have to do with the removal of a Justice of the Supreme Court and not necessarily a Chief Justice.
Chief Justice. So, then this particular provision in this article strictly applies, so that then you wouldn't have to import any other ruling in the case of Ejechum and others. This strictly applies.
Yes.
Because it's not a Chief Justice.
Exactly.
It's a Superior Court judge.
Yes.
Okay, let's get
So that's why we needed to emphasize the point that the removal process for the 2 individuals is separate. So when you look at it, 1461 says that the Justice of the Superior Court, or in this case, let's just stick to what it is, because we know what it is.
Absolutely.
This is Justice of the Superior Court.
Perfect.
We're not dealing with chairman of regional tribunals. Shall not be removed from office except for stated misbehavior and incompetence or on ground of inability to perform the functions of his office arising from infirmity of body and mind, that the Justice of the Superior Court of Adjudicator may only be removed in accordance with the prescribed, with the procedure specified in this article. Now, this is where it begins. This is the procedural aspect of it.
That's right.
That where the President receives a petition for the removal of a Justice of a Superior Court other than the Chief Justice, and for the removal of, he shall refer the petition to the Chief Justice.
Right.
When the President receives, he shall refer it to the Chief Justice, who shall determine whether there's a prima facie case.
So let's stay with that a bit. So in this particular the clause in this article, from what we saw in the case of the removed Chief Justice,
yes,
a 5-member committee was set up. But this time around,
but let's see, we still haven't got there yet.
Let's go.
Yes, because remember, a prima facie was determined before the committee was set up. So we are still at a point where it says that when the President, upon receipt of that petition,
so which has been done now,
that's what we are learning.
Right.
But of course, receipts will also be acknowledged from the presidency.
Absolutely.
So we are hoping that if indeed it's been submitted as it's been reported, then the presidency would issue a statement to that effect, if they are minded to communicate the status of how things are shaping out. It's important to
say they are not obliged to let us know.
If it progresses, they would have to.
Yes, but
we have seen that in the case of the removed Chief Justice.
Absolutely.
Where we were informed that some petitions had been received and what the process was, and that was the beginning of the legal hurdles for that. But as we speak now, what we gather is that it has been. Except we have not heard from the presidency exactly what the status of it is.
Right.
But of course, for purposes of education, if it ever progresses, this is the procedure we are looking at.
Absolutely.
From the president to the Chief Justice, now we have an acting Chief Justice.
Yes.
So, and then there will also be a determination of a prima facie. This time around, this prima facie is determined by the Chief Justice. Mind you, in the other procedure that I've seen in respect of the Chief Justice, it was done together with the Council of State, the President of the Council of State. In this case, it's the Chief Justice who does that. Now, after that where the Chief Justice decides that it's a prima facie case, he shall set up a committee consisting. You see that this provision is very clear as to who does what. That he, the Chief Justice, shall set up a committee consisting of 3 justices of the Superior Courts. There again, you see the distinction. In the case of the Chief Justice, Chief Justice,
yes,
there were 2 Superior Court justices. In this case, there are 3 of the Superior Court justices. They are appointed by the council, the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State.
Right.
So clearly, there's another distinction here. In the case of the Chief Justice, you have 2 justices of the Superior Court. In fact, in that particular one, is 2 justices of the Supreme Court. This talks about 3 justices of the Superior Courts. So it could include justices from the High Court, Court of Appeal, and the Superior Court itself. So now that takes us back to those who argued that the processes were different. What they were essentially arguing is that if Justice Gertrude Tukono were to be removed as a justice of the Supreme Court, she ought to have gone through this process, and not one that had 2 justices of the Supreme Court, and basically, so that's the controversy which is ongoing, for which the Attorney General is seeking an interpretation. Absolutely. That's a matter which is still pending. But just like I said, for purposes of education. Now, upon the composition of this particular committee, the committee appointed under Clause 4 of the article shall investigate the complaint and shall make its recommendations to the Chief Justice, who shall forward it to the President. There again, you see a distinction that when the committee that was looking into the matter of the Chief Justice were done, they forwarded their recommendations straight to the President. They went and met the President, handed over that envelope. In this case, they are saying that the Chief Justice will make the recommendations. No. Let's stay here. Yes. Investigate the complaint and shall make its recommendations to the Chief Justice. So the committee goes to the Chief Justice, who then forwards it to the President. Then it continues. So where the petition is for the removal of the... No, this is for the Chief Justice. Application. Yes. So the committee appointed under Clause 6, this is also in respect of the Chief Justice. But essentially, what it also ends in is the fact that whatever recommendations are contained in that, the findings of the committee will be those that the President will be bound by. So the President shall, in each case here refers to, be it in respect of the Justice of the Superior Court or the Chief Justice, act in accordance with the recommendations of the committee. So this is how it generally looks like, should this ever progress to the next stage. But like you said, this is what we are gathering based on the complaint that was made to the CID. We do know what the complaint generally is, and now we are learning that that complaint again has been put in the petition, which has been sent to the presidency, seeking the removal of His Lordship, Justice Yoni Kulendi. And this person we're talking about is Daniel Mafo Foriata. Yes, and Daniel from Chebi. That's Daniel Mafo, yes, Foriata. We have his picture. That's the man in black next to Richard Jakpa. Precisely. Right. I see. And it's early days yet on this. It's one that we're looking at and following quite closely, as we did indicate. If the presidency is minded, as we saw in the case of the process as was started, where the former Chief Justice Gertrude Araba-Isaba Tukono, Felix Kwachofosu issued a press statement telling us about the receipt of the petitions. This time around, we haven't heard or seen any press statement whatsoever acknowledging receipt of this petition that is said to have been sent by this Daniel Mafo Oforiata
but it's one that we're picking up and following quite closely. The signals of this petition at the presidency and what's going to be happening in the coming days. So stay with us here on Ghana Tonight. But there's one other issue as well that we're learning this evening, which we've also been following quite closely, and that's coming up next. It has also to do with another individual on that list that we just showed you. The General Legal Counsel has begun hearing a misconduct complaint against former Attorney General Godfrey Yabuadame over the ambulance trial. We've got the latest on this. Stay with us here on Ghana Tonight. And this is as well one that has been unfolding by the hour earlier today. And this is Ghana Tonight. Listen, this is, we touched on the complaint yesterday. Then this process has started today. What do we know, Dennis?
So, as part of the mini legs of this, I think this is one of the matters you can describe as looking like an octopus. Absolutely. Because it's almost everywhere. Mm-hmm. We did indicate that as part of the fallout from this ambulance trial, quite a number of things. Beyond the complaints to the CID, the petition to the presidency, there was also another complaint that was made to the General Legal Counsel in respect of the former Attorney General, the Leonard Godfrey Yabuadame. The complaint was to the effect that the way he went about the matter smacks of some misconduct, professional misconduct, for which this complainant wanted the General Legal Counsel to look at. That was somewhere in May. Mm-hmm. And we are now learning that the processes have kick-started. Now, mind you, the in-camera principle that applies to Article 146 proceedings also applies in respect of proceedings before the General Legal Counsel when it has to do with professional misconduct. So that also means that we are unable to get the detailed information by way of what exactly has been said, but we've been able to glean some information as to what stage of the process it is now, mm-hmm. and what essentially has been going on. So what we do know is that the former Attorney General has now given an answer to the complaint. So I usually, when the complaint is made to the General Legal Counsel, upon receipt of that, then they will make the complaint available to the respondent or the affected person to also answer to what the complaint, the issues that are raised by the complainants. Mm. So that has been done. So the former Attorney General has now given a response. In other words, he has responded to the complaints.
Okay.
That we understand or we gather that in doing so, he responded in about 6 parts. I mean, how he went about his presentation to respond in 6 parts. The first part, raising preliminary objections as to the way the complaint itself has been carried. Mm-hmm. Mind you, I had mentioned that it is supposed to be an in-camera proceeding. Mm-hmm. What it means, by the same principle, is that the complaint itself should not be published. But he observed that on the 22nd day of May, when this complaint was made, it was widely publicized. Radio, TV, in newspapers. He thinks that it breaches the principle of the in-camera proceedings. So, to that extent, mm-hmm. he raises the objection that it should be dismissed because already it has breached the rules of the procedure.
So it's in the public domain?
Exactly.
Okay.
Then again, he raises an issue about the capacity of the complainant himself, who claims to come under a certain provision of the Constitution. It is the view of the Attorney General, the former Attorney General, that to come under that provision without a personal injury does not clothe him with that capacity to come before the committee. So, in that respect, he wants that the committee dismisses the petition. Beyond the preliminary objections that we understand he raised, he also mm-hmm. went into matters about jurisdiction, raising issues of prosecutorial immunity, suggests that as an Attorney General, he was not doing whatever he was doing in his personal capacity. He was carrying through his constitutional mandate. To that extent, such persons should be protected in a sense. He urges the committee not to exercise jurisdiction on that particular matter. However, he continues, as we gather, to say that if they are minded to continue, then he would give them the factual background. That is to say, his side of the story. And that's why he began to recount his side of the story, mm-hmm. his engagement with Mr. Jakpa, together with His Lordship Justice Yoni Kulendi, and what transpired.
That's right.
Then he went on to, as it were, deny the specific allegations that have been made against him in respect of the claims of professional misconduct and all that. He concludes by saying that the complaint should be dismissed because it has no merit. So essentially, that is what we have been able to gather in respect of the matters that are before the General Legal Counsel. But that is to say, this is a process which is in motion, unlike the others that we are unable to tell exactly where they are now. In respect of this, we do know that the process is in motion.
And it's one that we're following quite closely. What is interesting is that in the case of this petition brought before the General Legal Counsel against Godfrey Eboadame, the petitioner in this case, or the person who filed this complaint, Daniel Ofoswapia.
Yes.
That's his name, Daniel Ofoswapia. And in the case of Richard Jagba and also Yoni Kulendi, Justice Yoni Kulendi, is Daniel Mafo Oforiata. The Daniels are onto something.
That's an interesting observation.
Indeed.
I didn't really pay attention to that.
They are onto something, but we'll see how things play out.
Exactly.
But thank you. Thank you so much, Dennis Boberry. This is gone out tonight. And as always, trust that. So far, I want to find out from you. We've seen this inflation rate, single digit, 9.4%. Over the last at least 7 months, we've seen a consistent reduction in the price. That's the rate of inflation. But then, what does this really mean? There certainly is a story behind the statistics we've seen, how this impacts on the economy, as we've seen now. Prof.
Okay, thank you very much. I think it's good news. Inflation has consistently been on the decline as a reflection of government policies. If you look at where inflation was December 2024, 23.8%, and now we are talking about inflation of 9.4%. I think if you look at within this period, the rate of deceleration or the rate of decline, I think is quite of good, and I think it's something that will be a relief to consumers. Of course, we are seeing that from September last year to September this year, prices on the average have gone up by 9.4%. Per world average, we can say that, yes, it's not like it's outstanding, or even if we compare this to our regional peers or our structural peers, some of them are doing far better than us. But given where we have come from, this is positive. This is good news. Again, if you also look at the disaggregation of the inflation numbers, if you look at the food inflation, that is where a lot of Ghanaians will be concerned, especially those at the lower end of the income quintile. They will be more concerned because food inflation is still double digits at 11%, even though the average inflation is 9.4%. So food inflation is still high, double digits. Of course, it has come down. We appreciate that, but it's still double digit. So we need to work on the food inflation and make sure that that also comes down significantly, because that is what takes between 42 to 44% of household expenditure in Ghana. Okay, and given that income levels are very low, when food inflation is that high, then it's problematic. But I think that we need to look at that side and make sure that once we're able to bring down food inflation, then it will drag the overall inflation downwards considerably, because non-food inflation is in the single digit zone, whilst food inflation is a double digit. The other thing to also take note is that on month-on-month basis, you will see that inflation is positive at 0.9%. Okay, it's not outstanding anyway, but it's still positive. It means that prices on the average are going up, okay, but not so significantly, so to speak, compared that to maybe last year. That's good. The other thing that I want to draw the attention of our listeners to, and also government, is to look at the inflation on locally produced items compared to imported inflation. You will see that the advantage is on the side of those who import rather than those who produce locally or produce from here. So that is also another thing that government will have to look at, so that we tilt the advantage towards producing locally compared to importing, of course, because of the aggressive strengthening of the currency, even though we've seen some some kind of correction in terms of the exchange rates, imported inflation is lower. And if you compare that to locally produced inflation, then one is the baseline interpretation is that one is better off actually importing rather than producing here. I believe that government will be looking at the data so that going forward, we begin to put in place measures that will make production more competitive and cheaper compared to actually importing and then paying all the duties. What is also important is that because we are surrounded by neighbors with far lower VAT rates, because the standard VAT rate in Nigeria is 7.5%. Our standard VAT rate, but effectively, our VAT rate is around 22% approximately, or 21.9%. Now, if you look at those regional dynamics and all of that, it may be cheaper actually importing, and if it's possible to smuggle those goods in through unapproved routes, which we think is happening in this country, also giving